Not so much.
All right, good morning, everyone. Welcome to Forum. Thank you for being with us. I'm going to try and get a jump on the time because I'm quite sure that the halls probably have lots to talk to us about this morning. So I'll just talk about some of the upcoming events that you're seeing scrolling behind me. We'll get some of those items out of the way. Next couple of weeks. So next week, the 29th, of course, is Palm Sunday, so no forum. However, there are events that are happening, so please check your church emails. For those, it should be a fun time. And then, of course, Easter the following week. And then we do have Jenny Owen from Indivisible coming the week after, on April 12th. So you won't want to miss that. It'll be probably a great planning session, an opportunity to talk about all the upcoming events through Indivisible. And then skip a few weeks. We have JWW sessions during the 19th. The 26th is the JWW lectureship series. And then the post-discussion group here in Forum on the 3rd, May 3rd. Followed up by the Immigrant Advocacy Team is presenting Annette Levia. She'll be speaking on behalf of Colorado Immigrant Rights Coalition. So that will be a really good event. But today, we are very honored to have, once again, the Halls with us. Judge Richard Hall and his son Eric Hall. If I can give our administration one bit of credit, I suppose it's the sheer volume of legal cases. So hey, congratulations. And the Halls are here today, once again, to help us dissect one such case, the tariff case. Briefly, I will just mention that Richard and Eric have spoken many times in the past. Last year, in 2025, they spoke on faith and curriculum, 2021, 2019, 2016, quite a few chances that they have come to speak with us. So you want to check our archives on the YouTube and study up on some of those previous forum lectures that have been so excellent. Eric Hall is an attorney here in town with Sparks Wilson, and his father, Richard Hall, is a retired municipal judge. And I will keep these introductions brief and turn it over to them right away so that we can hear from them. Please welcome the Halls.
Yes. Correction on that. He's a district court judge and has been for 45 years.
Christine Hall.
Okay, so great to be with you all. Today we're talking about the tariff case. We have outlines, so if you don't have an outline and want an outline, look for the stack because they are around. We're just going to work through the outlines. This case is called Learning Resources versus Trump. It was decided February 20th, 2026 by the U.S. Supreme Court. And just starting at the very top, the holding of the case. So if someone asks you, hey, you went to the forum, what'd you learn? Well, you can say, here's what I learned. That the International Emergency Economic Powers Act, known as IEPA, I'm going to say IEPA a lot, and that's what I'm referring to, that act, does not authorize the president to impose tariffs. That's the holding. One sentence, that's what this case is all about. It was a 6-3 decision. The majority was Chief Justice Roberts, Gorsuch, Barrett, Sotomayor, Kagan, and Jackson. And for you Supreme Court watchers, then you go, oh, we have 3 conservatives and 3 liberals in the majority, right? The dissent was Kavanaugh, Thomas, and Alito. So 3 conservatives in dissent. I'm going to talk about the majority opinion. I'm going to spend roughly 30 minutes, maybe a little bit less than that. I'm going through the majority opinion. My dad will talk about the dissents, the 2 dissents from Kavanaugh and Thomas, and then we'll open it up for questions. So write your questions down, think about your questions, because we'll answer them at the end. Okay, so what I'm going to now say is all drawn from the majority opinion, which means Roberts' opinion, okay? So he starts off by talking about IEPA, and here's what he tells us about IEPA. The International Emergency Powers Act was passed by Congress in 1977. It's codified at 50 U.S.C. 1701, so you can Google that and read it for yourself. Congress, very short version of what IEPA does, Congress passed IEPA. It granted to the president certain economic tools to address significant foreign threats. That's the super short summary of what IEPA did that the majority lays out in its opinion. To trigger IEPA, the court says basically a president has to do two things. One, it has to identify an extraordinary threat, and two, he has to declare an emergency. So if the president does those two things, then it can trigger IEPA. So if a president, any president, does those two things, identifies a threat, declares a national emergency, then here's the statutory language. So this is the heart of the case. Here's it's interpreting the statute, and the verbs in the statute are, some of them, not all of them. The president may take various actions such as investigate, block, regulate. Why is regulate in bold? Because that's the verb that the Trump administration put all their weight on. They say regulate plus importation means they could impose tariffs. I mean, that's the whole argument. All right. Anyway, investigate, block, regulate, directly compel, nullify, prohibit. Those are some of the verbs from the statute, and those verbs then go with a president can do these things: investigate acquisitions, holdings, use, transfer, transportation, importation, or exportation. Again, why is that in bold? Because again, the administration said we can impose these tariffs because we are regulating importation. Regulating importation, right? That's their argument. Importantly, the majority notes, at the very bottom of page 1, IEPA says nothing about taxes, tariffs, duties, raising revenue. There's no language in IEPA about any of those things, and that's important to the majority. Now on to page 2, where the majority describes the history of how we got here. In early 2025, the majority tells us, President Trump invoked IEPA by identifying two external threats. Threat number 1, the influx of illegal drugs from Canada, Mexico, and China, which, according to the president, created a public health crisis. So that's threat number 1. Threat number 2, large and persistent trade deficits. And this created two problems, according to the president: the hollowing out of the American manufacturing base and the undermining of critical supply chains. So there you go. That's the first part of how you trigger IEPA. He identified threats. He identified those two threats. Then he goes on to say, and this is an emergency. So the president declares the emergency. Okay, so now we got the two things. We got identifying the threats. We have declaring the emergency. On this foundation, Trump then said, okay, well now IEPA allows me to regulate importation, to impose tariffs on imports from any country of any product at any rate for any amount of time. Right? So that's the majority lays that out. The majority says this is what the president is doing, right? Relying on this statutory language from IEPA, is then saying this is the power that IEPA gives me. I can impose tariffs from any country of any product at any rate for any amount of time. You can imagine with that language, the majority is very skeptical that, and in fact holds, no, actually IEPA doesn't do that, right? But so the majority emphasizes that point. Okay, so then here's the reasoning. And when I say, again, to be clear, when I say the majority, I mean all 6, right? Because there is a part of Roberts' opinion not joined by the 3 liberals, only joined by the 3 conservatives in the majority. We're going to get to that. But this part here is joined by the entire 6. Okay, so here's what the majority does. The majority starts with Article 1, Section 8, Clause 1. So all of you know, because you're very smart, educated people, you know that the Constitution has 3 articles at the beginning: Article 1, Article 2, Article 3. Article 1 is Congress's power, the legislative power. Article 1, Section 8 is the part of the Constitution that lays out, here are the powers given to Congress, right? The federal government is a government of limited powers. And what powers does it have? Well, the legislature has the powers listed in Article 1, Section 8. And the first one, Clause 1, under Article 1, Section 8, is the Congress shall have power to lay and collect taxes, duties, imposts, and excises. So again, that's the language right out of the Constitution. You can look it up and read it for yourself. That's the power of Congress. Now, then the court goes on to say, the whole power of taxation rests with Congress. That quotation is taken from a prior U.S. Supreme Court case. I didn't give you the citations, but if you want to look it up, you could see a different U.S. Supreme Court case from some point in the history. The court said that this power granted to Congress under Article 1, Section 8, Clause 1 gives the whole power of taxation with Congress, not with the president, not with the judiciary, but with Congress. Okay, that's super important. During oral argument, Trump's lawyer to the U.S. Supreme Court conceded that the president does not believe that he had some sort of inherent authority as president to impose tariffs during peacetime. So if you listen to the oral argument, which I did, you hear this back and forth. And at one point, one of the justices asks his lawyer, are you saying that the president has power under, say, Article 2 to impose tariffs during peacetime? No, I'm not saying that. That's not what my argument is. Rather, that Congress delegated the power to impose these tariffs under IEPA. And that's what the court rejects. Okay. And also, Trump's administration, Trump did not say that he was invoking his war-making powers as commander-in-chief, because we all know that the president is the commander-in-chief under the Constitution. But Trump was saying, nope, I'm not saying that there's a war right now. I'm not invoking my powers, my war-making powers that maybe gives me tariff power. No, but I'm not doing that. Again, it's all under IEPA. Okay. So then the court goes on to say the power to tax is special. Essentially, that's the heart of the case, right? And that tariffs are taxes, the two parts on the bottom of page 2, because the court says, hey, the power to tax is special. It's different. It's a different power in kind from other sorts of powers. If you reject that, then you reject the majority opinion, because that's what the majority rests its weight on. And then it has a whole lot of quotes from different prior U.S. Supreme Court cases. The power to tax is the most important power. The power to tax is the power to destroy. The power to tax is necessary to the existence of a nation. The power to tax is the one great power upon which the whole national fabric is based. The founders fought a revolution in large part because they objected to taxation without representation. Only Congress has access to the pockets of the people in the Declaration of Independence. Paragraph 19, Thomas Jefferson objected to King George III, quote, imposing taxes on us without our consent. So all of this, the court lays out saying, here's all the precedent, all the history showing the power to tax is special. If someone from the federal government wants to take money from the pockets of the people, us, right, it's got to go through Congress. It's got to go through Congress. Okay, then, majority goes on to say.
Can I ask you a question?
Yeah, absolutely.
Is the word tariffs not in the Constitution?
The closest you get is what I put there in the middle, Article 1, Section 8. So it doesn't say tariffs, it just says collect and lay taxes, duties, imposts, and excises. So no, it doesn't say tariffs, but then there's all this precedent that talks about how, bottom page 2, tariffs are taxes. So the Constitution doesn't say tariffs, but it does say taxes, and then all this precedent saying, we all know that tariffs are taxes. So when Article 1, Section 8 says taxes and duties, that is synonymous with tariffs, right?
Tariff falls under.
Tariff falls under that. Tariff is a type of tax, a type of duty. Okay, great question. All right. Again, a tariff is a tax levied on imports. Again, citation to a different case. Tariffs raise revenue. The framers, when you go way back in history, at the beginning of our country, expected that early on the federal government would depend chiefly on tariffs. So when our country got started, the idea is we're just going to use tariffs to raise revenue. We're not going to actually tax the people of early America with like direct taxes. We're just going to have tariffs, and that's going to be all the federal government's revenue early on. Okay, this was super interesting, I thought. The very bottom, Congress's first exercise of its taxing power in its history was a tariff law. So the first time it passed any sort of law related to taxes, it passed a tariff law. And actually, that was the second law ever passed. Isn't that interesting? Oh, I love that. The second law in the history of the United States that was passed.
What was the first, out of curiosity?
That's on the next page. Good thing you asked. The first law, top page 3, was that new officials had to take an oath of office. Kind of let down, you know? An oath of office, but that was the first law, that a federal official had to take an oath of office. That's the very first law ever passed by Congress. And then the second law was this law imposing tariffs. Okay. So then the majority goes on and says, listen, through IEEPA, Congress did not grant the president the power to impose tariffs. Again, IEEPA does not mention tariffs, duties, taxes, or raising revenue. The power to, quote, regulate importation does not grant this authority. The U.S. Code is replete with statutes that permit the executive branch to, quote, regulate. However, none of them permit them to tax. I remember during oral argument, Justice Barrett asked the Solicitor General, okay, there are so many statutes in the U.S. Code that use the word regulate. Do any of them allow them to tax? And you can see, no, they don't. There are none of them that allow them to tax. Okay. To read regulate to include the power to tax would render IEEPA partly unconstitutional. This was an interesting argument. I didn't know this. Because Trump relies on regulate importation, but remember the full phrase when you read IEEPA is regulate importation or exportation. Those are the next two words in the statute. And Article 1, Section 9, Clause 5 says the Constitution forbids taxing exports. So again, if you say, okay, Trump, your argument is you can regulate importation, well, that means Congress wrote you can regulate importation or exportation, but we know from Article 1, Section 9, Clause 5 that you can't regulate exportation, means you can't tax exportation, if regulate is supposed to mean tax or impose tariffs, because that clause says you can't, it forbids taxing exports. So Congress would have been enacting an unconstitutional provision. Okay. 8 other verbs in IEEPA, near regulate, give the president power to sanction foreign actors or control domestic actors, but none of them allow for raising revenue, which again, the majority emphasizes is a distinct type of power. Trump, with his lawyers, said, well, listen, regulate lies between these two poles that the statute does contemplate. On the one hand, we have compel, right, the verb compel in IEEPA, so the president using IEEPA can compel either domestic or foreign actors to do certain things. And on the other end, there's prohibit. So you can compel someone, you can prohibit someone. So then Trump argues, well, then regulate importation is in between those. You can impose tariffs, which is in between, either compelling or prohibiting. But again, the majority replies, no. Tariffs because they're taxes are different in kind, not different in degree. They're different in kind. And then there's because everyone was asking, even at the time and subsequent, well, couldn't Trump and even Kavanaugh, my dad will touch on this, even Kavanaugh says in his dissent, well, Trump can just impose new tariffs through some other statute, right? So in footnote 4 of the majority opinion, the majority touches on this very, very briefly. The majority says, well, listen, sure, Justice Kavanaugh cites these other statutes where he says, oh, the president could just impose tariffs through these other statutes, but it notes, well, these other statutes actually have some procedural prerequisites, that they have some required agency determinations, i.e. whatever agency within the executive branch has to do certain things, have to make certain findings or something like that. The agency has to do something. It's not like the president can just say it through an executive order, right? And these other statutes that Kavanaugh relies on, they have limits. Congress said, okay, sure, executive branch, you can, if you do these procedural things, agency finds certain things, then there are limits on the duration, the amount, and the scope of the tariffs. So again, it wouldn't give Trump the ability to just tariff whatever oil product for however long from any country, right, however much at the time. Anyway, but very short sentence on that, and then the majority goes on to say in that same footnote 4, listen, we'll address future cases based on other statutes when they're properly brought before the court. We're not going to just opine about this right now. That would be giving an advisory opinion, which the court is not going to do. Okay, that's the majority opinion. That's essentially the sum of the majority opinion. The next part of the opinion is only joined by Roberts, Gorsuch, and Barrett, the three conservatives within the majority. And it's all about what's called the major questions doctrine. So you all love the Supreme Court. I'm sure you're very up on the doctrines, the various Supreme Court doctrines. This is a big one, the major questions doctrine. So the court writes about it in parts 2A and 3 of the majority opinion. Those were not joined by the three liberal justices. But anyway, very briefly, the major questions doctrine is a doctrine that the Supreme Court has employed in this case and other cases, where essentially what it means is the Supreme Court is skeptical when the executive branch claims broad, expansive power on an uncertain statutory basis. And that's what the Supreme Court said Trump was doing here with IEPA, saying you have this very thin reed, this very thin statutory basis of regulate importation within the context of IEPA, and you're claiming this massive power to impose any sort of tariffs you want for as long as on any product from any country, right? Like, we're very skeptical of that under the major questions doctrine. Then the court, the majority, points out, well, the three justices within the majority say, here are other examples of major question doctrine cases. And this will be like a hit parade for all of you. Because you're like, remember, oh yeah, the Supreme Court struck down Biden's attempt to forgive $430 billion in student loan debt in Biden versus Nebraska, 2023. It relied on the major questions doctrine to do that because the majority thought the same sort of thing. President Biden was trying to do the same thing, trying to claim a huge power, i.e. forgiving $430 billion in student debt based upon very shaky statutory language, right? Like, do we really think Congress granted you that power with this language? No, we don't. So in that case, it said, no, Biden, you don't have that power. And you recall the student loan debt wasn't forgiven because the court struck it down. Next, the EPA attempt to force a nationwide transition away from coal. That's West Virginia versus EPA in 2022. Same sort of thing. The EPA said, oh yeah, we're going to use this statutory language from this one statute. We're going to claim that gives us the power to say, essentially, coal power plants need to go out of existence here and sometime soon. And they got sued, and the court said, no, the language you're relying on is not sufficient. Next case. Remember OSHA. Oh, we loved COVID, right in the COVID vaccine mandate. Politically, people were all over the place on that, but the court said when OSHA tried to use, again, what the court thought was pretty skeptical statutory basis to impose the COVID vaccine mandate on 84 million Americans, the court in National Federation of Independent Business versus OSHA said, no. Same sort of thing. You're taking this very thin statutory read and you're trying to have this massive power from it. We're skeptical as the court. We strike it down. So they struck it down on that too. There are other cases too, but those are some of the more recent big ones. When Congress has delegated its tariff power, the three justices in the majority said, it has done so, one, in very explicit terms, and two, subject to strict limits. That's not what IEPA shows here, right? That is not what IEPA has done. According to the president, there are no limits on what he can do under IEPA. And then the court notes that, okay, for Congress, so the president can declare an emergency, all right, we all know that, but for Congress to terminate an emergency, it has to pass a law. And as we all know, if it passes a law, the president can veto the law. So for Congress to end an emergency that the president declares, it would have to have a veto-proof majority in Congress. So that's a very high bar for Congress to be able to check the president's power through passing a law to end an emergency declared by the president. There's lots of good case law, which I didn't put in the outline, from prior Supreme Court cases where the court has said things like, you know what, when Congress said the president has to declare an emergency, it kind of tends to make the president to declare a lot of emergencies, like through history. We've kind of seen that as a matter of historical fact. We think that's what's going on here. So let's see. According to Trump, Congress delegated this expansive tariff power to the president, where the only way Congress could reverse it was by a veto-proof majority. Last couple points. No other president in history has invoked IEPA to impose tariffs. let alone tariffs of this magnitude and scope. Now, my dad's going to get up here and say, but Kavanaugh has this long argument about that might be true, but statutory predecessors to IEPA that use similar language, presidents have used the similar language from predecessors to impose tariffs. That's a big part of what Kavanaugh says gave President Trump this power. Anyway, the majority didn't agree with that. And then the last thing, number 7 here, the majority rejects the argument that there is a, quote, major questions exception to the major questions doctrine. That's in response to Kavanaugh, because again, Kavanaugh recognizes the major questions doctrine and has joined it in prior opinions. Here, doesn't join it, thinks it doesn't apply, and part of the reason is because Kavanaugh essentially says, well, there's a major question exception to the major questions doctrine, and here the major question exception applies. And Roberts is like, no, we reject that. Okay, that's the major questions doctrine, like three justice part of the majority opinion. Then we have a bunch of concurrences. And the concurrences go on for a long, long time. Well, at least Gorsuch's go on for a long time. 46 pages of concurrence from Gorsuch. And you know what he does? I've never seen this before in any case I've ever read. What Gorsuch does is he critiques every other justice, except Roberts. He goes through by name, and he says, in this case, he said, well, Kagan, Sotomayor, and Jackson, they're inconsistent because they supported Biden's use of essentially the same sort of thing, and here now they're saying, oh, Trump does. So Gorsuch, again, according to him, calls them out as inconsistent. He then critiques Barrett by saying, oh, Barrett, she's joining me here, but she's got this other version of major questions doctrine. That's wrong. And then Kavanaugh is wrong too because he thinks that he provides a cushion. Anyway, he critiques Thomas. Thomas thinks that the Congress can delegate any and all of its powers to the president. Anyway, for 46 pages, he critiques every single other justice. Wow. It makes it kind of difficult in the Supreme Court building now for him to get along with everybody else. Anyway, the one part of Gorsuch's opinion which I did like was at the very end, I'm now on the top of page 5, he ends by saying, listen, there is a reason that Congress, when Congress enacts legislation, it's designed to be difficult. I know lots of people are frustrated with the fact that Congress isn't doing anything, it's not passing legislation, Congress is doing nothing. But there's a reason it takes time to pass legislation because the legislative process is the bulwark for liberty. So I'd recommend you flip to the very end of Gorsuch's concurrence and read that because I like that. I won't go into the other parts, Barrett, Kagan, and Jackson. Essentially, they're defending themselves from Gorsuch. And so I will end there and let my dad take over and talk about what the dissents said.
Well, that's very scholarly. But I would like to get a little motion in the things here. You recall when this decision came out of the Supreme Court, President Trump called the Supreme Court traitors. He said they were idiots. You recall the State of the Union address. The Supreme Court justices normally sit in a pew down at the right front, in the front row. Only 4 justices showed up for the State of the Union this year, and President Trump insulted them again during his State of the Union address, said it was an unfortunate decision, and he was very upset with them. So this is a big deal politically. It's a big deal economically because we're talking about billions of dollars, but I think we need to keep in mind what Trump is really upset about. 3 of his 6 conservative justices just plain disagree with him in a very public way, something that he made a big deal out of. So that's what we're talking about when we get to Kavanaugh's dissent. Kavanaugh starts out with a little history. In 1971, President Nixon imposed tariffs using a different statute, and that was challenged and upheld in court. 4 years later, in 1975, President Ford imposed tariffs using a statute which talked about adjusting imports. And that led to a Supreme Court case, Federal Energy Administration versus Algonquin SNG, referred to as the Algonquin case. Based upon that procedural history, Kavanaugh says that when Congress got around to adopting IEPA in 1977, just 1 year after the Algonquin case, Congress would have plainly understood that tariffs were authorized when they passed the IEPA statute. Not only does it say that Congress would have plainly understood it, he said that it is utterly implausible to think that Congress would have understood to the contrary, that any member of Congress who did think to the contrary had his, quote, head in the sand, that no rational member of Congress would think that it's all but impossible to conclude that Congress was excluding tariffs when it adopted IEPA, and that Congress would have been plainly aware, indeed, how could they not be, when they passed IEPA. He then goes on to say if Congress had wanted to exclude tariffs from IEPA, why did they use the exact same language that had been in an earlier statute? TWEA stands for the Trading with the Enemy Act. That was passed back in 1917 during World War I. And he says, neither the plaintiffs nor the court have a good answer to that question because there isn't one. Now you can say something once in a Supreme Court opinion when you're trying to make a point. You can say it twice if you're trying to emphasize the point. But to say it 7 times and pretty much declare that you think that members of Congress were just plain stupid is remarkable. And when he says that, he's also implicitly saying the 6 justices in the majority are equally stupid. It was clearly decided, according to Kavanaugh, with the Algonquin case, that the president could impose tariffs. And there was nothing wrong with that. He also points out that during oral argument, the president's lawyers and the Supreme Court both acknowledged the president could impose quotas and embargoes under the statute, which means he could cut off trade, absolutely everything. So he could say China cannot import anything. And that would be authorized. But the president cannot impose a $1 tariff on things and let the trade come in. And Kavanaugh says that doesn't make any sense. Tariffs are just a less extreme, more flexible way of dealing with imports. So he is just plain adamant that Congress had authorized tariffs by these earlier actions by Nixon and Ford and by the Algonquin case, and that it's just, what is the majority opinion talking about? He then goes through some historical situations. During the Mexican-American War, President Polk permitted imports from Mexico upon the payment of tariffs. During the Civil War, President Lincoln lifted the blockade of Confederate ports and allowed some trade subject to fees. During the Spanish-American War, President McKinley imported duties on any occupation of forts in the Philippines. And all of those actions were upheld by Supreme Court opinions. Why do these wartime examples matter? Because during World War I, Congress adopted the Trading with the Enemies Act, which authorized, or which set down in statutory terms, the president's wartime powers. Then, during the Depression, Congress amended the TWAA to allow the president to impose tariffs during national emergencies. It didn't have to be during a war, it would be just during a national emergency. Then in 1941, shortly after Pearl Harbor, the TWA was amended again to allow the president to, quote, regulate importation. That language appears in the TWA and has been there for 50 years, 60 years. Then in 1977, the TWA was amended again, and it allowed the president to impose tariffs only during wartime, but they passed the IEPA statute, which allowed the imposition of tariffs during national emergencies. And according to Kavanaugh, IEPA was directly drawn from the language in Trading with the Enemies Act and used the exact same language about regulating ... importation. In Kavanaugh's opinion, today's case should follow just as a matter of course from the Algonquin case. There was no meaningful daylight between the two statutory phrases, adjust imports and regulation of imports. And the plaintiffs and the majority opinion do not even try to distinguish between the phrases, nor could they. He claims that the majority opinion tried to explain away Algonquin on two different grounds. One, that the statute talked about the president taking such action as he deems necessary. Why, IEPA doesn't have that language. But in Kavanaugh's opinion, Algonquin didn't rely upon that language. It just relied upon the question of whether adjusting imports allowed monetary charges, i.e. tariffs. The majority opinion put in Kavanaugh tries to distinguish Algonquin by saying that the former statute did mention duties. However, the Algonquin court did not mention that provision, did not rely upon that provision, because that provision had to do with repealing existing duties. It has nothing to do with the question of allowing new duties or tariffs. He comes back to his point, if Congress, that had amended the IEPA, wanted to exclude the presidential power to impose tariffs, which he says already existed because of the Algonquin case, it wouldn't have used the exact same language. Or, if they wanted to exclude tariffs, they would have said so. But Congress didn't do either one. It's Kavanaugh's opinion that the power to impose tariffs already existed, and if anything was going to be done about it, Congress had to exclude tariffs. The majority opinion is that there was nothing one way or the other on the subject, so Congress would have had to explicitly include tariffs. And then we have the question of what happens when there's no particular statutory language one way or the other. Then Kavanaugh, discusses the major question doctrine. In his opinion, it relies upon two overlapping presumptions. The separation of powers presumption, that Congress, as the legislative branch of government, has separate powers from the executive branch of government. And if anybody's going to impose policy, it will be Congress, not the president. And second, that Congress would intend to make any major policy decisions itself. And he says that the major questions doctrine doesn't apply in this case for two reasons. One, as argued above, there was clear congressional authority when the TWA got passed and amended, when IEPA was first enacted. And second, it doesn't apply to issues involving foreign affairs. He claims that foreign affairs are different than domestic policy for a variety of reasons. One, tariffs are sometimes used as bargaining chips in negotiating treaties. If you don't cooperate with us on this particular point, we'll impose a tariff on you. If you don't allow us to sell goods to you, we'll impose a tariff on you. Foreign affairs are sometimes governed by international law. It's not made by Congress. And because of that, it's not really Congress's discretion at stake, it's the president's discretion. And therefore, he claims that foreign affairs are different than domestic affairs. And therefore, the major questions doctrine simply does not apply. He gives two interesting examples of other situations where the so-called foreign affairs exception, in his mind, allowed the president to do something that wasn't specifically authorized in a particular statute. They're mentioned on whatever page this is, Mahdi versus Rumsfeld and Baines and Gore versus Reagan. I won't go into them because we're running out of time and we don't want to get to questions. But he makes the claim that those are examples where the president did something that wasn't specifically authorized by any statute, and yet the president's actions were upheld by the Supreme Court as something within his discretion. So that's Kavanaugh's opinion. He took 63 pages to say all that. The entire opinion for majority concurrences and dissents was 158 pages long, which is a hugely lengthy Supreme Court opinion. It shows how seriously everybody was taking this thing. Justice Thomas wrote another dissent, which in my opinion really didn't say anything helpful.
That sounds like Thomas.
He talks about how the legislature has core legislative powers. The basic can't be dealt with any other way. And those are matters that relate to the deprivation of, the taking away of, life, liberty, and property. Anything else is not a core legislative policy, so it can be delegated. Whether the power to impose tariffs can be delegated really wasn't the issue in this case. The issue was whether it was delegated. And Thomas doesn't really get into that. He acknowledges that the major questions doctrine exists, but he made no effort to discuss why he didn't think it was applicable in this case. So he didn't, in my opinion, help us very much. So that's the dissent from Justice Kavanaugh. With that, we will open up to any questions you might have about anything. Yes, sir.
So I have a question pertaining to what are the cases that previously occurred beforehand. I believe it was Trump. Oh, sorry. Sure.
Repeat the question.
So lately, the Supreme Court has been rather inconsistent with its rulings, it seems, because in the past there was a Supreme Court case that basically said Trump had a more broad authority, if you will, that goes beyond what is the purviews of his office. And does this case contradict that previous ruling in that case?
Well, I think the history of the Supreme Court for the last 5 or 6 years has generally been to uphold whatever Trump did. There was a sense that they were just sort of going along with him because they were in his pocket. That's what makes this so big. That 3 of the 6 conservative justices ruled against him on a very public, emotional, everybody was aware of problem. That's why he called the Supreme Court terrorists and traitors. That's why he insulted them during the State of the Union address. He just didn't like the idea that 3 justices conservative justices ruled against it. Yes, ma'am?
First thing that occurred to me is I was a French major, and the French remind you all the time that if it's not clear, it's not French. And when I was studying in Europe, I actually learned that Germans frequently study German philosophy in French because it makes it clear. So when you talked about adjust versus regulate, is the problem in part our English language, that there's not a common understanding about a lot of those issues?
Well, the decision didn't get into German philosophy.
Or French language?
The majority opinion does make a big deal out of if Congress was going to give the president the power and the authority to impose tariffs, they would have said so, or they should have said so directly and clearly. So we didn't have to guess about it. We didn't have to speculate about it. That's what the major questions doctrine of the three justices meant. And so, yes, as I understand the German language, they tend to have very precise verbs and nouns on. They say what they want to say. And Supreme Court opinion is Congress should have done that in this case, if that's what they meant to have happen. Yes, ma'am.
Trump has said, never mind, there's other ways I'll impose tariffs. What would those be?
Well, Kavanaugh mentions a whole series of statutes in his opinion. As he put it, perhaps Congress just checked the wrong statutory box. There are other statutes that do allow the president to impose tariffs. And as I mentioned, as a note in my outline, one day after the Supreme Court announced its opinion, Trump invoked one of those other statutes, Section 122 of the Trade Act of 1974 or something. Trump had been asked about this upcoming decision before it came out. And he said, well, we've got other ways to deal with the situation. And sure enough, one day later, he used a different statute to impose tariffs. That's now being challenged by lawsuits. It's going to work its way through the court system. We'll get a decision from the Supreme Court next year on that particular question. Yes, sir.
Is there any sense in the rulings that the tariffs should be refunded?
Well, that's discussed. Kavanaugh acknowledges that people are going to ask for refunds. And in his opinion, that process is going to be a mess. I have seen articles which say, no, it's not going to be a mess because the Customs Department of some branch of government has it all on the computer. They know perfectly well who paid tariffs because the money goes into the U.S. Treasury. And so the government knows where the money came from. There are already lots and lots of lawsuits asking for refunds. Now, the next question is, if the importing company that paid a couple $1 million in refunds and they get their money back, are they going to pass that on to the eventual customers? Now, we can all have seen articles saying, well, the price of gasoline's gone up, the price of groceries have gone up, and to some extent that's caused by the tariffs. Well, that may be true, it's a matter of great debate, but if you paid $1.50 more for a tank full of gas, you are not going to make a claim for a refund. So the question is, are Amazon and the other really large companies that pay millions of dollars in tariffs, and they get their money back, are we local peasants at the bottom of the food chain going to get our money back? And that's also to be decided. So yes, the whole question of refunds, big deal, billions of dollars. I have read that some hedge funds, for example, are buying up refund claims. And they're going to file multi-billion-dollar lawsuits, and they're going to try to collect all those refunds. Yes, sir.
I'd like to ask each of you, if you were on the Supreme Court, what side would you be on, and briefly why?
Well, I have to acknowledge, I think Kavanaugh makes some good arguments legally in his opinion, in his dissent. We do have the Algonquin case. He mentions in a footnote in his opinion, if today's opinion is correct, Algonquin was wrong. But the majority opinion does not overrule Algonquin. It just sort of leaves it there. Yes, Nixon and Ford imposed tariffs, and those were upheld by courts. So if you believe in the idea of a precedent controlling what today's decision should be, I think Kavanaugh has a good argument. On the other hand, I think what we have seen is some justices maybe a little nervous about President Trump doing a whole variety of things and a whole bunch of topics, and feeling that his authority as president should be trimmed down a little.
So
There are other major Supreme Court opinions coming up, like the birthright citizenship case. Eric and I are waiting for that to come out so that we can prepare a talk on that. A lot of people are wondering whether this marks some sort of philosophical shift in the majority of justices on the Supreme Court. And we can all wait and see.
You haven't answered the question, Dad.
Whoa! I felt like that's
Nail on that.
I probably would have been on the side of the majority. I think the major questions doctrine needs to be considered. It applies not just to actions of the president, it applies to any branch of the executive government. So all the departments and agencies also make big decisions that affect us all. And perhaps they need to be reined in a bit.
So my answer is majority for sure. I thought this case was going to be 9-0. I was surprised when we had 3 dissents. I'm like, are you kidding me? But then I also believe that the Constitution gives limited power to the federal government, and Congress's power is, articulated in Article in Section 8, and taxing power is clearly given to Congress. So I start with all of those understandings of how our Constitution is structured. And so when I first heard of Trump, using this obscure statute to impose these massive tariffs, I'm like, really? And then when I read Roberts' opinion, it's only 21 pages long. So Roberts' opinion is short, to the point. I think it's super persuasive. I definitely would have joined it. I also would join the major questions doctrine. I agree with that doctrine. So I would join that too. And I think for that reason as well, I would have joined it. So, I definitely would have joined the majority. I thought, when I read Kavanaugh's opinion, I'm like, okay, he actually has some good points. I thought we'd have no good points. I think his opinion is very cobbled together, and he's like trying to stitch together things that don't hold up. And as I read it, I'm like, no. And I thought Roberts actually did distinguish Algonquin, distinguish all of the other points very effectively. I know Kavanaugh says he didn't, but that's what rhetoric is all about. That's what lawyers do. So I did not find Kavanaugh's opinion persuasive. I agree with my dad that Thomas's opinion was on a different subject, the non-delegation doctrine. Majority for sure. I thought this should have been 9-0.
Thank you.
I don't know that I personally agree with some of the majority opinion, which is based primarily on the power to tax. I think Kavanaugh is correct that tariffs are also used to affect one way or the other whether you want to use the word regulate or you want to use some other word, tariffs are used as negotiating items when enacting treaties with other countries. Tariffs are used sometimes if somebody thinks there's a huge flood of television sets from Japan, well, impose a 50% tariff on them and cut them down so the local and American industries can sell more television sets. I think tariffs do have a function beyond simply raising money. Yes, sir.
It seemed to me that the fundamental question was, what's the emergency? And how does this power address that emergency? And it seemed like that was just a little window, well, we'll declare an emergency and then we'll just expand it. But it seems that somewhere along the line, that emergency has to regulate the extent to which tariffs can be applied. If you have a specific emergency that a specific tariff would help mitigate, yes.
Well, I would to some extent agree with you. I'm not sure that tariffs have much to do with drugs coming in from Mexico. I think tariffs do have something to do with trade deficits, that our balance of payments in the world economy is, we got too much money going out, not a lot of money coming in. So I think on the second national emergency that President Trump relied upon, assuming he's correct in his declaration, I think tariffs can be used to deal with the idea of trade deficits.
But is it?
Yes, sir.
Follow up.
I don't see Alito mentioned here. You go Thomas and Kavanaugh, but I can't find it. Did Alito sort of vote with the minority but didn't write anything?
No,
or?
Alito was in the dissent.
Yeah, I
There were
know
3
that.
dissents, but he didn't write an opinion.
Okay, he didn't write an opinion. Okay.
And I think Sotomayor didn't write an opinion either. 7 of the justices out of 9 wrote something about this case. Some of their concurrences were 4 or 5 pages long, but 7 out of 9 of them felt necessary to say something about the case.
I have a question, piggybacking on Frank's a little bit. It seems like what is considered an emergency is a subjective judgment, and would it ever be the place of the Supreme Court to, I mean, they can't point to the Constitution and say, this is outlined as an emergency, this is.
I don't know what the criteria are for declaring emergencies, but as Eric referred to, the president can pretty much do it.
Right.
Then if Congress wants to override it and said, no, that's not an emergency, they would have to pass a statute. And then the president could veto the statute.
But what about the judicial branch? What's the part on that?
I don't know, there have been any court cases about whether a presidential emergency was legitimate or not.
Yeah, right.
But we see emergencies all the time. Governors impose emergencies when there are floods or wildfires or whatever.
Right.
The whole idea of the chief executive officer of a governmental unit saying there is an emergency and this is what it is, that happens pretty frequently.
Well, yeah, my point is it seems it could be hard for the judicial branch to use in their argument that we didn't think that was a sufficient.
Well, when we get a Supreme Court case on that topic, we'll let you know.
Okay.
I just don't know if, that's an interesting legal question, if you did legal research on, are there cases from the Supreme Court or other courts where a court has said, no, that's not an emergency. You, state government, federal government, president, whoever, say it's an emergency, but we, the judiciary, are declaring it's not. I just don't know whether courts have done that. They may have. I'm not sure. My sense from reading the majority opinion is that courts have not done that, and they just say, yeah, we recognize that the president can declare it, Congress can override the president, but we, the courts, are just, we're not going to say that we have the ability to police that, but I might be wrong. That courts may have done that. I'm not sure.
I would think courts would not want to get involved. I mean, that's a can of worms.
That's a tough one.
You spend your life on that stuff.
Yeah.
With all the infighting and some of these opinions, is that a break with decorum? Is this something we should keep an eye on?
Well, as Eric pointed out, Gorsuch's opinion criticized everybody else. Kavanaugh's opinion, in effect, called the majority underheads. This was a pretty snippy opinion between the justices, which is, I think, another thing that makes it
Notable.
unusual.
I mean, we'll see. I don't know. I mean, Scalia would definitely take it to people, right? Brennan, going further back, would take it to people. So I think there's definitely some of that. Is this? I don't think this is necessarily a break, but it is. I think something worth watching. Different justices, I think, have different writing styles as to how acerbic they want to be of their colleagues. Some more, some less.
Well, I thought it was significant during the State of the Union. Only 4 justices showed up at the State of the Union. That's sort of a ceremonial big deal in Washington. And usually, only of them show up. And they sit in a pew in the front row, right down to the left-hand side of the president. This year, only 4 of them showed up.
Which 4?
Which was interpreted by a lot of people to be a bit of a reaction to the president insulting them. Well, the Chief Justice was there because he was there. Barrett was there.
Thomas.
I don't know who the other 2 were. I think Thomas was there. You can recognize Thomas.
You can Google it, I'm sure.
Only 4 of them showed up. And a lot of people said they were just sort of annoyed at being insulted by the president.
Last question?
Yes.
This may be pretty far-fetched, but I believe you said that during wartime, the president can do a lot of things without approval. And I'm wondering if that was part of his decision, because we are now at war. So can he now do?
Well, as Eric pointed out during oral argument, the attorneys for the president specifically said President Trump is not relying upon his position as commander-in-chief and as what he can do during wartime. So this had nothing to do with our thought that a war existed.
Would an official war need to be declared by Congress?
Well, that's a subject for another day. Congress has not declared war since World War II.
Right.
What we have nowadays are authorizations to use military force, abbreviated as AUMS. That's what we had in the Gulf War, that's what we had in the Afghanistan War. If you ask, that's probably what Trump is relying upon now. So
Korea also was not a declared.
Korea wasn't official. That was the argument of the anti-war protesters during Vietnam. Congress had not declared war, so if I participated in this, I'd be a war criminal. And there were court cases said it was not true.
We could easily go another hour. Thank you.
Thank you.
Those guys on NPR this morning. The director.
Of course,
They realize.